Good morning. Are you DeJuan Banks? This is 25 DCCR 0990. Mr. Banks is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Judge, I've gotten some contact with some family members who are also family members to the complainant involved. Got that over to Ms. Mofino. We're trying to get that resolved, and I get in contact with them as soon as possible. They're out of state, so it's kind of been the difficulty.
Right, looks like he's been in custody since October.
It's been a while, Judge. We've had some issues with trying to resolve some CPS issues. Initially, the child has also been placed multiple. Trying to locate the child without saying too much has been somewhat difficult.
Okay.
That there is family that's involved on both sides. We also had a guardhouse issue. We brought him over and since watched the guardhouse. So just that final conversation, if we can some way or how, either via phone or Zoom or something, all of us together, since they're out of state, before we put it on the trial docket. Once we get to the trial docket, it's gonna be up in the air, just depending on what I'm able to do with respect to witnesses, etc. I certainly understand his having been in custody because I don't feel like the child is here locally. If Mr. Lewis wants to approach him on the issue, I don't.
So let's do this. I'm going to reset it. This will be the final reset for an announcement. Whatever you guys need to figure out between now and then, if it's going to go in the trial docket, if you file a motion for bond reduction, I'll take a look at it. But it's definitely time to get something moving. I understand the issues that you guys have had, but it's time to.
Right away, you can see the judge's patience starting to run thin. This case has been delayed for months because of witness issues, CPS complications, and difficulties locating the alleged child victim. But notice what the judge is signaling here. Delays may be understandable, but they can't continue forever. At some point, the court has to move the case forward. Do you think the judge is being fair by granting one final reset, or should this case have been pushed to trial sooner?
Do something. So this will be the last reset for an announcement.
No.
All right, you can go back with the bailiff.
Thank you.
Mr. Parker, you have Jeremy Alexander.
Because of enhancement, does it make sense? Yeah.
Good morning. Are you Jeremy Germain Alexander?
Yes.
And Mr. Alexander, this is cause number 26, DCCR 0178. You're charged with the third-degree felony offense of injury to an elderly individual from November 17th of 2025. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, May 10th of 2021. What that means, sir, is that if you go to trial and you're found guilty in this offense, then the range of punishment, if that prior conviction is true, would be enhanced to a second-degree felony, which means your minimum punishment would be 2 years up to 20 years in prison. Do you understand? I need you to answer out loud for the record, please. And I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are today if you wanted to plead guilty.
Yes.
You understand all of that?
Yes.
You want to reject that offer and have your case set for trial.
Yes.
We'll get that done. Mr. Smith, is there any reason to believe that there would be a change in that offer? You've got everything as far as discovery.
This is one of those moments defendants spend sleepless nights thinking about. Alexander has just rejected an 8-year plea offer despite facing an enhanced punishment range of up to 20 years if convicted at trial. That's a huge gamble. Sometimes defendants reject deals because they believe they're innocent. Other times, they think the prosecution's case isn't strong enough to win. Either way, the stakes just got dramatically higher. What would you do? Take the certainty of the plea deal or risk everything in front of the jury?
So I want to make sure you understand, Mr. Alexander, that after today, I'll be accepting this offer. Some new evidence comes up that the attorneys don't know about. You understand?
Yeah.
All right. And so Mr. Alexander, Mr. Parker's been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
That's fine.
All right, so Mr. Parker, you're released. Mr. Alexander, someone will be appointed today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Edward Godfrey. Good morning. Are you Edward Godfrey III? And will your client waive the formal reading of the indictment?
No, Your Honor.
Mr. Godfrey, in cause number 26, DCCR 0383, you're charged with the third-degree felony offense of assault, family violence, by impeding breath or circulation from February 6th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for an 8-year deferred probation. Is that right? Is that right?
I wrote it in 8, but
That was the original, but it was a 6. I haven't
but
got
I,
to a 6
but I,
here.
but I had it 6. I didn't
It should be 6.
read it wrong. It's
Okay.
6.
So, with y'all's permission, can I change this
Yeah.
punishment recommendation? So it looks like the agreement is for a 6-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
No.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Godfrey is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to...
Notice how carefully the judge is handling this plea. Before accepting any guilty plea, the court has to make sure the defendant understands exactly what rights are being waived and what consequences could follow. That's why you hear questions about competency, voluntariness, and even immigration status. It might sound routine, but these safeguards are designed to prevent defendants from making life-changing decisions without fully understanding them.
reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing at a later date. Is there juvenile history? He was certified. You were certified as an adult in this case? How old are you?
He's 17.
You're 17. Okay.
I don't show any histories.
I guess I'm trying to figure out why he's in green.
How long you been 17?
Since November. Okay, so you were 17 when this was committed, but they've got to keep you separated. So you won't be 18 until this November. I am going to...
This is an unusual and important detail. Godfrey is only 17 years old and has been certified as an adult, meaning he's being prosecuted in adult court despite still being a minor. Judges often pay very close attention to pre-sentence reports in cases involving young defendants because they want a complete picture before deciding punishment. The court isn't just looking at the crime, it's looking at the person who committed it and whether rehabilitation is still realistic.
leave the bond the way it is. I want to see that pre-sentence report based on this age and the nature of the offense and make sure there's everything in place and there's nothing else that we need to do to make sure Mr. Godfrey is successful. All right, you go back with the bailiff. We'll see you back at sentencing. Charles Hairston.
He has a case like out of Van Zandt County. This guy's got mastered stuff. He says a little dare. He has a problem is he wants to farm out, but he has a bond in Van Zandt County, 300,000. What he's trying to prove. I told him to put problem number. He's it's 15.
Good morning, sir. Are you Charles Hairston II?
Yes, ma'am.
And Mr. Hairston, in cause number 24 DCCR 2426, you're charged with a third-degree felony offense of theft of property from November 18th of 2024. And what that means in that case, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And then in cause number...
Now this is where things get interesting. Charles Hairston has just turned down plea deals that would have resolved both of his cases without a trial. That's a major legal gamble. Prosecutors have shown their hand, and now he's betting that taking the case to trial gives him a better chance than accepting the offer on the table. Interview 1.
24 DCCR 2427, you're charged with a state jail felony offense of credit or debit card abuse from November 13th.
And here's another defendant choosing the trial route. What's fascinating is that Hairston wasn't offered prison time in these plea deals. He was offered deferred probation. That means successful completion could potentially keep him from serving time behind bars. Rejecting those offers suggests he either believes he can beat the charges or sees problems with the prosecution's evidence. Trials can be powerful opportunities for defendants, but they're also high-risk, high-reward battles.
Of 2024. And what that means is if you're found guilty in that case is that the range of punishment would be between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
In each of those cases, I have here on the tablet some plea bargain rejections that you've signed with Mr. Parker. It looks like the district attorney's office has made an offer in the theft of property case for a 10-year deferred probation with restitution, and then in that credit debit card abuse, a 5-year deferred probation. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes.
All right, we'll get them set for trial. And Mr. Hairston, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes.
All right, Mr. Parker, you're released. Mr. Hairston, we will appoint someone today.
This exchange highlights something many people misunderstand about the legal system. A judge's authority is generally limited to cases within their own jurisdiction. Even if this judge wanted to help with the other county's bond issue, legally, there's very little she can do. It's a reminder that defendants facing charges in multiple counties often have to navigate several separate legal battles at the same time, a situation that can quickly become overwhelming.
They should be out to see you very soon to begin preparation for trial.
Judge, I would say he's talked to me about the bond reduction in these cases. I've explained to him I think the bonds are probably appropriate. He's trying to bond out. There's another case out of Van Zandt County, and the bond's like, I don't know what the charges are, but it's like $300,000. I told him that this court had no control over anything there.
No, I can't do anything with those bonds. When your new attorney comes to visit you, if they want to file a motion for me to try to reduce these, I'll take a look at it at that point. But I can't do anything that has to do with any other county. All right? Okay, you can go back with the bailiff. Tamara Henry.
Courtroom session comes to an end. We saw defendants facing life-changing decisions, some accepting responsibility, others choosing to fight their cases in court. One thing is certain: every choice made in this courtroom carries consequences. That can last for years. Which case stood out to you the most? And do you think the defendants made the right decisions?